are going to be looking at relief from the impact of the COVID-19 virus under FIDIC 2017, courtesy of Chidi Egbochue, who's one of the construction partners, who's going to share his expertise with us. At the end of the session, he will take any questions that you may have. So if you can just pop those in the chat box to me as we go along, I'll keep a list and make sure Chidi gets around to them at the end of the session. So without any more ado, Chidi, it's over to you.
Okay, good evening. Okay, here's a little bit about me. I'm a non-contentious construction law specialist, but I'm also experienced in disputes work. I have 13 years of experience advising on construction projects across numerous sectors, the infrastructure, energy, etc. And in particular, I have extensive experience and knowledge of construction procurement and standard forms of contract such as JCT, NEC3 and NEC4, FIDIC, Logic, IChemE, and so forth. Okay, so this evening, what I'm going to talk about is the impact of the COVID-19 virus and the various provisions under FIDIC 2017. When I refer to FIDIC 2017, I'm referring to the FIDIC 2017 yellow, silver, and red book. For those of you who are familiar with FIDIC, FIDIC brought in a second edition of the red, yellow, and silver books. The first edition were published in 1999, and in 2017, FIDIC brought in a second edition of these books. The red book is normally used for traditional procurement, where the employer has responsibility for producing the design. The yellow book is often used with package procurement, where you have several contracts, several packages with several contractors. Therefore, you have a contractor for each of those packages, where the contractor will have design responsibility, but the employer has responsibility for integrating all of those various work packages to form the complete project. I mean, one example of that might be a wind farm project, where you would have wind turbines as one package, balance of plant as another package. And the yellow book is a turnkey form of contract. So it's used where you have a single contractor who has full responsibility for delivering the project. And the idea being that the single contractor takes design responsibility, takes all responsibility, and then he delivers a project to you that you can then operate and maintain. Simply by turning the key, you put the project into operation. Now, on the slides, you can see that essentially what I'm going to do, I'm going to run through FIDIC 2017. I'm actually going to focus on the red book, but the provisions that I'm discussing, they generally apply equally to the yellow and silver books as well. I'm actually going to discuss these provisions in the order of that the clauses appear in FIDIC, the FIDIC red book. And essentially, I'm going to talk about provisions that deal with delay and disruption. So given the delay and disruption caused by the COVID-19 virus, these are the provisions which anybody who is operating under on a project involving red, yellow, or silver book, which has been affected by the COVID-19 virus. These are the provisions that they should be looking at. So that's the first part of the agenda you can see on the slides. The second part of the agenda on this slide, and then the final part of the agenda. And as you can see, right at the end, I'm going to set out some brief conclusions, and then as Julie mentioned, I will take any questions. Okay. Okay, so the first interesting thing is that obviously, as I've mentioned, FIDIC is intended to be used on international projects. Now, the FIDIC 2017 Rainbow Suite, as I mentioned, is the second edition, following on from the first edition in 1999. Since 1999, or between 1999 and 2017, there have been several worldwide viruses. We had the severe acute respiratory syndrome, which affected places like Hong Kong in particular. I used to live in Hong Kong. In fact, I left just before this virus really took hold. We also had swine flu in 2009, 2010. We had Middle East respiratory syndrome in 2012 and still ongoing. We've obviously had Ebola as well in 2013, 2016. There has in fact been a more recent sort of outbreak of Ebola in Africa, although not the same countries from which where it occurred the first time. And we've also had the Zika virus. So the point being that there have obviously been many viruses between the two editions of the FIDIC yellow, silver, and red books. So FIDIC has had ample opportunity, if you like, to contemplate that there may be epidemics or pandemics which delay or disrupt international construction projects, and therefore should be taken into account in the drafting of the FIDIC 2017 suite of contracts. Okay, so the first obvious thing is that obviously is the notices provision. We're obviously at a time where a lot of people are working from home. A lot of people do not have, it's not easy for anybody now to perhaps sign documents, send originals in a post and so forth. So it's always very interesting to see what notices provisions there are in contracts, because if you fail to actually comply with the notices provision, then you run the risk that the relevant notice will be invalid and ineffective. And that might be, for example, a notice of adjudication, or a notice of dissatisfaction with a decision or determination of the engineer. So notices are always extremely important, and therefore one thing you always look for whenever a dispute arises is whether the relevant notice has in fact been served properly and is in the correct form. Now, FIDIC provides that notices are to be in writing, and that they are to be either signed originals or electronic originals generated from the systems of electronic transmissions set out in the contract, such as email, or if there are none stated in the contract, then in some form of electronics transmission, which is acceptable to the engineer. FIDIC also goes on to say notices may have to be both written and in electronic form. So that's obviously something to look out for. I can't off the top of my head recall where in the FIDIC contracts provision is made for notices to be both paper originals and electronic originals, but obviously it would appear from at least the notices provision that FIDIC contemplates that in some cases that will be required. So unless that has been amended in your contract, obviously it's one to look out for and make sure that you comply with. Assignment, unsurprisingly, FIDIC provides that either party may, as security in favour of a bank or financial institution, assign rights to money. So obviously this, in the case of a contractor may in the current circumstances, seek some sort of financing funding, and therefore it may wish to assign its right to receive monies under the contract. Well, if the contract hasn't been this particular provision hasn't been amended, this is expressly provided for in the FIDIC contracts. So compliance with laws. Clause 1.13 states that in performing the contract, the parties must comply with applicable laws. Now that statement is important because essentially it means that not only will you fall foul of the law if you obviously do not comply with applicable law, such as the COVID-19 regulations, but also you would that failure to comply would also constitute a breach of the contract. FIDIC clause 4.8 goes on to say that the contractor must comply with all applicable health regulations and laws and health and safety obligations specified in the contract. It must comply with all directives issued by its health and safety officer, and it must take care of the health and safety of all persons to be on the site. Well, these provisions, although they are quite generic, you can see how they could possibly apply, particularly in relation to the COVID-19 virus, the requirements for social distancing, etc. So you could quite easily see how if one is not complying with new safety requirements as a result of the virus, that would amount to also falling foul of clause 4.8. FIDIC also requires the employer to ensure that its personnel and its other contractors similarly comply with similar health and safety obligations as required, as a contractor is required to comply with under clause 4.8. Just going on to compliance with law, there's been obviously some talk. COVID-19 virus is worldwide. There have been difficulties in obtaining equipment, plant, and materials because of various countries bringing into effect restrictions, and there have been delays, etc. So it's worth noting that under the FIDIC, there's an express statement that it's the contractor who is responsible for clearance and permits, and he's required, and he indemnifies the employer against all claims related to the import, transport, and handling of all goods. And goods means contractors' equipment, materials, plant, and temporary works. Further in clause 6.7, the contractor is required to take all necessary precautions to maintain the health and safety of its contractors' personnel. It goes on to say that in collaboration with the local health authorities, the contractor shall ensure that suitable arrangements are made for all necessary welfare and hygiene requirements and for the prevention of epidemics. So as you can see, this is the first specific reference in FIDIC 2017 to epidemics. So clearly such a provision will cover the COVID-19 virus. So in clause 6.9d, the engineer has the power to require the removal of any person employed on the site who persists in any conduct which is prejudicial to safety and health. So you could envisage a situation where somebody is simply perhaps not carrying out the required social distancing, and this continues, and he is perhaps warned, and then at some point the engineer essentially exercises his power under the Contract Act to require that person to be removed. The caps on liability and exclusions of liability. In the FIDIC contract, there's a mutual exclusion of liability for loss of profit, loss of any contract, an indirect or consequential loss. But it's also contemplated that there will be a cap on the contractor's liability. That cap is going to be the accepted contract amount unless a specific figure has been stated in the contract. But the interesting thing is that there is an exclusion from both the mutual exclusion of liability for consequential loss and from the cap on the contractor's liability. There's a carve-out for fraud, gross negligence, deliberate default, or reckless misconduct by the defaulting party. And I can envisage the possibility where somebody simply is negligent in carrying out their health and safety requirements, and it causes some loss to the employer, and the employer then brings a claim against the contractor. Contractor seeks to rely on these exclusions of consequential, etc., loss and or his cap or on his liability, and the employer turns around and says, well, actually, I think that what you did, what your personnel did, given rise to this claim, amounted to gross negligence. Now, there's no actual concept of gross negligence under English law, although there is under various European systems. But effectively, what I'm saying, it is something to look out for. If the conduct can go so far as to possibly take the contractor out of the exclusions of and caps on his liability. Also, in clause 8.8, there's an express provision stating that the cap on delay damages in the contract, again, that cap on a contractor's liability will not apply in the case of fraud, gross negligence, deliberate default, or reckless misconduct. So again, I can envisage a situation where a project is delayed, and part of that delay might be because the contractor has not been doing the correct things regarding dealing with the COVID-19. So perhaps social distancing, so perhaps the project gets shut down by the health and safety executive, for example, and then the contractor seeks to rely on the cap on his delayed damages, and the employer says, no, I don't believe you can rely on that cap because I believe that your conduct amounted to gross negligence or deliberate default or reckless misconduct. Okay. FIDIC requires the employer to detail his financial arrangements in the contract data. Further, if the employer intends to make any material change to those arrangements, or he is forced to make a change to those arrangements as a result of a change in his financial situations, then he must immediately give a notice to the contractor with supporting particulars. Now, obviously, this is all aimed at giving the contractor comfort that the employer does have the funds to pay the contract price. And now, again, obviously, as a result of the COVID-19 crisis and the effect it has had on the economy, you can envisage a situation where employers may have some difficulty in their funding. So it's worth noting that they will, under the FIDIC contract, be required to give a notice to the contractor advising if there has been any change in their financial arrangements or position. And further, if the contractor himself becomes aware of the material change of the in the employer's financial arrangements, then the contractor is entitled to request reasonable evidence that the employer will be able to pay the part of the contract price that remains to be paid at that point in time. Regarding the contractor's performance security, under clause 4.2, the contractor is required to obtain at his own cost performance security in the amount and currency stated in the contract data. So typically this would be an on-demand performance bond for perhaps 10 to 15% of the contract price. The further performance security might be in the shape of parent company guarantees, but typically on the international projects you will certainly have a performance bond. Under clause 11.11, the contractor is required to ensure that the performance security remains valid and enforceable until the issue of the performance certificate, and compliance with clause 11.11, which requires the contractor to clear the site after the performance certificate has been issued. The performance certificate is issued under clause 11.9 within 28 days after the latest of the expiry dates of the defect notification periods, or soon thereafter, as a contractor has supplied all of the contract documents. So these are the O&M manuals and the as-built documents, and the contractor has completed and tested all the works, including remedying the defects. And so the important thing to note is that the performance security is required to remain valid right up to and to the expiry of the defect notification period. So it's not just up to the completion of the works and issue of the taken over certificate, but all the way up to completion of remedying of defects and expiry of defect notification periods. Now, obviously, projects which are suffering delay and disruption may find that they essentially now have to go back to their bondsman and say, well, actually, we need the performance security to be extended because of these delays. An on-demand performance bond will have a long stop date in it. And under the FIDIC contract, there are extendable pay provisions, which essentially require the contractor to, if the performance bond is going to expire, they require the contractor to go off to the bondsman and get those bonds extended. Failing which, the employer will be entitled to actually claim whatever amount is then available under the performance bond and hold that amount, which obviously would be a disastrous situation for the contractor. But the interesting thing is that obviously the provision states that the contractor must obtain the performance security at his own cost, and therefore it follows that delay, if the project is delayed and disrupted, and therefore the performance security has to be extended, then that will also be at the contractor's cost. However, if obviously the contractor is able to claim additional payments on a basis of one of the underlying reasons for the delay is a ground in the contract that entitles him to recover cost and possibly profit, then the contractor would obviously seek to also include the cost of having to extend any performance security in that claim. The progress reports, it's worthwhile reminding you that the contractor is required to submit monthly progress reports up to the date of completion or the completion of any outstanding works which are listed in the taken over certificate. Now, these monthly progress reports are required to set out detailed descriptions of progress, including procurement, manufacture and delivery, So what that obviously means is that if manufacture or delivery or progress or procurement is affected by COVID-19, then the contractor must provide details of the same in his monthly progress report. Health and safety statistics again have to be included in the monthly report, including details of any hazardous incidents or activities. So again, the contractor should be referring to issues with COVID-19. Perhaps there may be activities where social distancing may not be possible. These are things which should be mentioned. The contractor should be comparing actual and planned progress and should be detailing events, circumstances which may adversely affect completion and the measures that he is adopting to overcome the delays. So again, it's pretty obvious that any project affected by COVID-19 should be, the contractor should be mentioning what he is doing about it, both the effects of the COVID-19 virus on his project and what he is doing about it in his monthly progress report. It's also worth noting that the contractor is responsible for the security of the site. So even if the contractor decides that, or the employer decides that there's some agreement between the parties that the contractor should stop work because perhaps social distancing is not possible, the contractor does remain responsible for the security of the site, and therefore it follows that he must put in place measures to secure the site and keep the site secure during any stoppage. So nominated subcontractors, in some ways it's actually a surprise that FIDIC still provides for nominated subcontractors, because I think it's fair to say that nominated subcontractors have been the bane of employers' lives down the years, and I think it's fair to say employers avoid them like the plague. No pun obviously intended. But FIDIC does still include provision for nominated subcontractors, and the interesting, the valid, or the most important thing about nominated subcontractors is that the employer is entitled to, before he issues a payment certificate, which includes an amount payable to a nominated subcontractor, the engineer can request reasonable evidence that the subcontractor has received all payments in accordance with the subcontract. And if that evidence is not provided, and the contractor is not able to satisfy the engineer in writing that he's entitled to withhold or refuse payment, and has notified the subcontractor of that entitlement, then the employer, in his sole discretion, can make payment of the relevant sum directly to the nominated subcontractor, which can open up a real can of worms and the subcontractor and the contractor. It's the contractor who obviously is administering the subcontract, so it's not really a great position for an employer to find himself in. But obviously, if you are a subcontractor, you are a nominated subcontractor in the current climate, you might be quite happy to obviously see that if the contractor is suffering financial difficulties and therefore seeks to avoid paying you, then you can actually appeal to an employer to pay you directly. For the program, the contractor is required to submit a revised program which accurately reflects the progress of the works whenever he considers that the program no longer reflects accurately progress or is otherwise inconsistent with his obligations. The engineer may give a notice to the contractor that he must submit a revised program if the engineer considers that the program which he has previously signed off on, no longer reflects actual progress or is inconsistent with the contractor's obligations. And the contractor not only submits a revised program, but he also has to include a supporting report, which includes his proposals to overcome the effects of delays. Again, obviously, COVID-19 may cause delay, may require therefore the contractor to submit a revised program, and he also has to submit a supporting report setting out possible measures to overcome those delays. So the advanced warning provision, which is familiar to those of us who work on NEC contracts, that's something FIDIC decided to put into the FIDIC 2017 suite of contracts. So under clause 8.4, each of the parties and the engineer advise the others in advance of any known or probable future event or circumstances which may adversely affect the work of the contractor's personnel, increase the contract price, delay the execution of the works or any section. And the engineer may then respond by requiring the contractor to submit a proposal for a variation. So obviously, I could see I would expect the contractor and also the employee, in fact, and also the engineer to be issuing notices to each other or issuing advance warnings to each other regarding the impacts of the COVID-19 virus, because not only will it affect the contractor, but it will also is also likely to affect the employer. The employer may find that he has personnel who are in quarantine or may have actually contracted the virus, and therefore he may suffer difficulties in administering the project from his end, and similarly from the looking at the engineer. So I would expect the parties and the engineer to have issued advance warnings to each other regarding the difficulties which they are suffering as a result of the COVID-19 virus. So acceleration, it's worth noting that where the project has fallen behind, and for reasons which do not entitle the contractor to extensions of time, then the engineer can ask the contractor to submit proposals such as a revised program describing revised methods to expedite progress, so that he will in fact complete the works or the section within the relevant time for completion. And subsequently, the engineer can actually ask the contractor to adopt the methods, which obviously are at the contractor's cost. But if similarly, or if you like, on the other hand, if the reasons for the delay are events which do entitle the contractor to an extension of time, then the engineer can again ask the contractor to adopt these methods, but these revised methods, but the way he would do that would be by issuing a variation instruction. So suspension, under clause 13, the engineer expressly has the power to instruct the contractor to suspend part or all of the progress of part or all of the works. If the reason for the suspension, suspension is if the contractor is not at fault, and so therefore he hasn't caused the suspension, then there are various reliefs which the contractor is entitled to under the contract. So one such relief is that the contractor is entitled to the payment of the value site if the work or the plant or delivery of the plant and or materials is suspended for more than 28 days. Now that's subject to the plant and/or materials having been scheduled for delivery to the site during the suspension period, and also that they do indeed comply with the contract and that they have been marked for the employer's. They have been marked as the employer's property in accordance with the engineer's instructions. Also, it's worth noting that the contractor has some protection regarding defect notification periods, because what could obviously happen is that if the project is suspended for a long time, then since defect notification periods normally commence at the time of taking over, then in essence the contractor would find himself providing perhaps longer defect notification period than he may have contracted or may have contemplated. And in particular, what can happen is that the contractor may have agreed certain fixed defect notification periods with his supply chain. Supply chain may be suppliers, and those periods may start therefore from when the goods are supplied. And therefore, if they are supplied and then there is a suspension, then the contractor could find himself in a situation where he has not been able to back off his own obligations regarding defects notification periods onto his subcontractors. Well, clause 11.3 provides the contractor with some relief, because it expressly provides that if delivery and/or erection of plant and/or materials is suspended, then the defect notification period is limited to 2 years after the date on which it would otherwise have expired. So whatever date it would have expired but for the suspension, it's limited to 2 years from that date. If the suspension continues for more than 84 days, then further suspension is agreed. Unless the contractor is willing to agree to a further suspension, the contractor becomes entitled to treat the suspension as a variation omitting works if the suspension affects only part of the works. But if it actually affects the whole of the works, the contractor is then entitled to terminate the contract under clause 16, which is obviously would be a drastic outcome for an employer. Further rights, there are further rights of suspension of the contractor himself. If the employer fails to certify under clause 14.6, so that's the issue of interim payment certificates, or the employer fails to pay the contractor and once a payment certificate has indeed been issued, or he fails to provide reasonable evidence of his financial arrangements, which we discussed earlier, and that failure can be constitutes a material breach of the employer's obligations. And in all those cases, the contractor is entitled to suspend by giving 21 days notice. I mean, it's worthwhile remembering that obviously if it's a UK project to which the Construction Act, that's the Housing Grants Construction and Regeneration Act 1996 as amended, if it's a project to which that act applies, then the contractor is entitled to suspend for non-payment on giving at least 7 days notice. So you couldn't provide for 21 days notice, you would have to provide for, he has a statutory right to suspend on giving 7 days notice. It's also worthy of note that the contractor is not allowed to remove from the site any major items of the contractor's equipment without the engineer's consent. Now that's quite harsh for contractors. Sometimes some of this equipment will be maybe cranes on some projects or vessels. There may be they may be very much a scarce resource, and the idea of having them tied up on a project, even during a suspension, could cause major difficulty for the contractor. On the other hand, looking at it from the employer's point of view, if he loses that equipment, such as vessels or cranes, it may be very difficult for the employer to get them back for his project once the suspension is lifted. And therefore that will cause a consequential delay to progress. It's worth noting that FIDIC, like many construction contracts, does provide for partial possession or partial completion. At the employer's sole discretion, the engineer may issue a taken over certificate for any part of the permanent work. So you could envisage a situation where COVID-19 virus has struck, the works cannot be completed, and the the employer is willing to take over the part of the works which have been completed, and require the engineers obviously to issue a taken over certificate for that part. In some cases, you may find employers who think to themselves, well, actually, we don't want to issue a taken, we don't want the engineer to issue a taken over certificate, because we want the contractor to remain on the hook for the full complement of delay damages, for the risk of loss or damage, and we don't want the defect notification period to start because the contractor hasn't completed all of the works, but at the same time, we do want to use part of the works. Well, if the employer was to proceed to use part of the works before a taken over certificate had been issued for it, then the contractor would be entitled to give a notice accordingly, and the relevant part will be deemed to have been taken over by the employer. The defects liability, under the contract, the employer gives the contractor notice if any defect or damage occurs during the relevant defects notification period. The parties then jointly inspect the defect or damage, and the contractor then prepares and submits a proposal for the necessary remedial works. Now, if the remedying of the defect or damage, you can envisage a situation that because of the COVID-19 virus, the contractor may struggle with resources, there may be difficulties in actually getting onto the site, and delays in remedying defects. So, well, clause 11.4 provides that if the remedying of any defect or damage is unduly delayed by the contractor, the employer may give a notice which shall allow the contractor reasonable time, taking due regard of all relevant circumstances to remedy the defect or damage. So I can imagine that the contractor will first of all argue that any delay caused by the COVID-19 means that it's not the contractor who is unduly delaying the remedying of the defect or damage. Further, I can see a contractor arguing that even if it can be said that he is unduly delaying the remedying of defects or damage, he must be given reasonable time, which must take into account the situation caused by the COVID-19 virus to remedy the defect or damage. It should be noted that if indeed the reasonable time has been given and the contractor fails to remedy the defect or damage within that time, then the employer is entitled to carry out the works, arrange for others to carry out the works, and claim his reasonable costs, or he can accept the defect or damage and require claim a reduction in the contract price, or he may treat the part of the works as an omission, or so a variation omitting work, or if the defect or damage deprives the employer of substantially the whole benefit of the works, then the employer is entitled to terminate the contract. So variations, it's worthwhile remembering that variations are not confined to changes to design or works, but indeed variations can include changes to sequencing or timing of the execution of the works or the omission of the work. So an employer or an engineer, an employer could decide that due to complications caused by the COVID-19 virus, he could himself take the initiative, or ask the engineers to take the initiative to actually change timing or sequencing of works, the execution of works, or even potentially omit works. So if there are works which it appears are will be just too difficult to complete in the current climate, so rather than suspending, he may actually require that work to be omitted. It's also worthwhile remembering that rather than proceeding to issue a variation instruction, the engineer can actually, in the first instance, ask the contractors to submit a proposal regarding the contemplated variation, which will set out the cost and time effects of that variation if it were to be instructed, and various other matters. So the engineer might be contemplating issuing an instruction, wants to know essentially what exposure the employer has and what are the time and cost effects if he's going to issue the instruction to deal with the COVID-19 virus. Therefore, the smart thing to do would be obviously to require the contractor to submit a proposal to him, so that he is obviously he issues that variation with the full knowledge of its consequences. There's certain the contractor has a right to object to variations in certain circumstances. If the varied work was unforeseeable, or if the contractor cannot readily obtain the goods required for the variation, or if the variation will adversely affect the contractor's ability to comply with his health and safety obligations under clause 4.8. In all of those instances, the contractor would be entitled to object to the variation. Unforeseeable is defined to mean not foreseeable by an experienced contractor at the base date. The base date will normally be, it may be the date of the contract, or it may be the date of submission of the contractor's tender. Okay, so change in laws. So this is one of the more obvious provisions which you would look at as a result of the COVID-19 virus situation, because obviously various governments have brought in emergency laws to seek to contain the impact of the virus. Under clause 113. Under clause 13.6, it's provided that the contract price shall be adjusted for any increase or decrease in cost caused by a change in the laws of the country, any change in any permit, permission, license, or approval obtained by the employer or the contractor under clause 113 A or B, or any change in the requirement for a permit, permission, or approval which is to be obtained by the contractor under 113B, and in each case the change having been made after the base date. So again, this obviously means that I would expect contractors to be saying, well, look, we have suffered additional costs because of measures which we have had to implement as a result of the COVID-19 virus. Therefore, we consider that we are entitled to obviously relief under clause 13.6. It also is stated that if it's necessary to make an adjustment to the execution of the work as a result of the change in law, so this I think could be the method of execution of the works, for example, then the contractor shall give notice to the engineer who shall instruct a variation. So again, I could see a contractor seeking to rely on this provision as a result of changes he's having to make to how he executes the works as a result of the COVID-19 virus regulations and laws that have been brought in. So price inflation, obviously, if projects are delayed and disrupted and suspended, and then it could well mean that there are price inflation occurs. There are rises in the cost of labour, possibly falls, but most likely rises in the cost of labour, goods, and other imports. Well, occasionally contracts may provide for price indexation, so there may be schedules of cost indexation included in the contract. FIDIC contemplates that might be the case. If that is the case, then obviously there may be some protection for contractors. But if there are no schedules of price indexation included in the contract, then the contractor has to just simply bear the risk of inflationary increases. So termination. Termination. The employer is entitled to terminate if the contractor doesn't comply with a notice to correct. So that's where the employer issues a notice informing the contractor that he is failing or has failed to comply with an obligation he has under the contract, and gives the contractor a period of time which shall be reasonable to cure that failure. So if the contractor fails to comply with that notice to correct, and such failure constitutes a material breach, well, that's a ground for the employer to terminate. A further ground is if a contractor abandons the works or otherwise plainly demonstrates an intention not to continue performance. So these are obviously things that could happen. A contractor doesn't feel comfortable with working on site, very worried about his personnel, or maybe it's his personnel, his subcontractors, very concerned about the virus. The employer doesn't want the site to be shut down. Maybe the main contractor also wants to continue working because they're on the hook for delay damages, but the subcontractors decide to walk off site. Well, obviously that might lead to the employer, the contractor not being able to service the project, and it could lead to a situation where the employer becomes entitled to terminate on the basis that the contractor has abandoned the works or plainly demonstrated his intention not to carry on, continue the performance of his obligations. A further ground is if without reasonable excuse, the contractor fails to proceed with the works. Again, if it's COVID-19, of course, the contractor will argue that any delay or disruption is not is a reasonable excuse why he's delaying or not proceeding with the works if it's caused by the virus. And further, if the employer becomes entitled to the delay damages which exceed the cap, so if the cap is 50% of the contract price and delays occur for which the contractor is not entitled to extension of time, such that the damages would exceed the cap if it wasn't obviously there, then that would also entitle the employer to terminate. Although in all of these cases, the contractor must be given a 14-day cure period. So he is given 14 days to cure the default. I'm not quite sure how he would cure a default where the delay damages cap has been exceeded, for example. But this is how FIDIC is drafted. I mean, what you would often, if you were acting for a contractor, you would often draft a contract to expressly state that the contractor can at his discretion continue paying delay damages over and above the cap in order to avoid the employer becoming entitled to terminate the contract. The employer also has the right to terminate the contract for his convenience. Any such termination will take effect 28 days after he's issued a notice to the contractor, but obviously the downside is that he would have to pay the profit which has been lost by the contractor, as well as all other losses and damages which the contractor has suffered as a result of the termination. But obviously the express right to terminate for convenience might suit a contractor if they consider that difficulties caused by the COVID-19 means that their project is no longer viable in its present form. In terms of the contractor terminating, we noted before that the contractor has the right to suspend in relation to payment and reasonable evidence of the employer's final financial arrangements, etc. Well, he also has rights to terminate in respect of the same, although obviously the periods of time are longer. So if the contractor does not receive reasonable evidence of the employer's financial arrangements within 42 days after he's given a notice under clause 16.1 for a failure to provide evidence of these arrangements, clause 16.1 is a suspension provision. So having issued a notice under clause 16.1 to suspend, if 42 days subsequently he still hasn't received the reasonable evidence of the employer's financial arrangements, then the contractor would be entitled to terminate. He also would be entitled to terminate if the engineer fails to issue a payment certificate. Now, again, if the Housing Grants Construction and Regeneration Act applied, which it would do to most construction projects in the UK, you wouldn't need this provision because they would, if in the absence of a payment notice from the paying party, the employer, a default. The contractor could himself serve a payment notice, or if the contractor has submitted a statement that would itself amount to a default payment notice. The contractor is also entitled to terminate if he doesn't receive the amount due under a payment certificate within 42 days after the date by which it should have been paid. Further, if the employer substantially fails to perform an obligation which constitutes a material breach, so you could envisage a situation where, for example, the employer doesn't give access. So as a result of the COVID-19, he simply doesn't provide access to a part of the site, then the contractor may argue that that's a substantial failure to perform an obligation, and it's one which constitutes a material breach and therefore entitles him to terminate. So for those projects where perhaps they were just about to get off the ground and then the virus struck and all the lockdown and all the various other measures ensued, it could be that an employer might then hold off issuing the notice of the commencement date. Well, if the contractor hasn't received the notice of the commencement date within 84 days after the letter of acceptance, so that's the letter accepting the contractor's tender, then that would be a further ground for the contractor to terminate. And as we discussed earlier, in the event of a prolonged suspension, so that's one more than 84 days, which affects the whole of the works, then that again would entitle the contractor to terminate. The contractor, similarly to the employer's right to terminate, the contractor has to give the employer a period which is 14 days, other than in relation to prolonged suspension, where the contractor can terminate immediately. Okay, so there's also a further provision. We'll come on to this to look at the definition of exceptional event. I can say now that exceptional event is defined in FIDIC. It's what we might was previously referred to as force majeure in the FIDIC 1999 edition. So if there has been if an exceptional event occurs which prevents the execution of substantially the whole of the works for a continuous period of 84 days, or for multiple periods which total more than 140 days, then either party can terminate by notice to the other, and that any such termination takes effect just 7 days after the notice. Okay, so the risk of loss or damage. The contractor is responsible for the care. So essentially, he bears the risk of loss or damage to the works, to the goods, contractor's documents in respect of any relevant section or part of the works from the commencement date until the relevant date for completion. So that's the date for completion of the section or the works as stated in the relevant taken over certificate. And at that point, the responsibility transfers to the employer, other than obviously in respect of any work which is outstanding, which as listed in the taken over certificate. However, the contractor has no liability for any loss or damage that's been caused by an exceptional event. So again, the point here is that even if the contractor, even if the project is suspended, even if it shut down for a period of time, the contractor is still responsible for the risk of loss or damage to the works. So he's not, any such suspension or closure of the project temporarily will not relieve the contractor from that responsibility for care of the works and the risk of loss or damage, and therefore a prudent contractor will, of course, put in place measures to protect the works even during any suspension or shutdown caused by in relation to the COVID-19 virus. Okay, indemnities. The contractor indemnifies the employer and his personnel and respective agents against third parties' claims for bodily injury, sickness, disease, or death of any person, which arises out of or in the course of or by reason of the contractor's execution of the works, unless attributable to negligence of or willful acts of breach of the contract by the employer or his personnel. Now, I think it possibly could be argued that where a contractor has continued, I mean, it's very, in most cases, I don't think this sort of public liability indemnity will come into the reckoning regarding in relation to COVID-19, simply because you wouldn't expect, well, I suppose the possibility is that you could have third parties who are performing some sort of I don't know, supervisory function, and therefore, because the works are continuing, there may be contractors personnel who have the virus, and maybe then those third parties contract the virus. So I suppose it's possible that the COVID-19 virus could cause some sort of public liability, third-party liability to arise. Although I think in most cases, I think the more likely position perhaps is other contractors of the employers. And so if because in most cases you would expect the sites to be pretty self-contained and with only contractors working on the sites, and therefore I wouldn't expect this indemnity liability under this indemnity in relation to the COVID-19 virus to occur very often. The employer, it's also worth noting, the employer indemnifies the contractor against third parties' claims for bodily injuries, sickness, disease, or death, which is attributable to the negligence or willful act or breach of the contract by the employer. Again, I don't think that, I wouldn't expect this indemnity to come into question, come into play as a result of the COVID-19 virus, but I suppose it's possible. Because I think that a contractor's not going to be argued that even if an employer insists on the contractor continuing to work, I don't think given what is known about the virus and given the various regulations and laws which have been passed, I don't think a contractor could argue that it was that's negligence on the part of the employer. What the contractor would have to do is follow the regulations, and if that means leaving the site, then that's what he should do. Okay, so an exceptional event, as I mentioned in the old FIDIC, and this there was no this was referred to as force majeure. It's not. There's no real difference, if you like, in the way it's been defined. It's just that it's now referred to as exceptional event because there's some sort of, if you like, uncertainty often when you use the term force majeure as to what you mean. So FIDIC have just decided to define what they mean and exceptional event. So an exceptional event is an event or circumstance which is beyond a party's control. The party could not have reasonably provided against before entering a contract, and having arisen, the party could not reasonably have avoided or overcome, and is not substantially attributable to the other party. There's also a list of matters which will constitute exceptional events if 1 to 4, which I've just read out, are satisfied, and they include war, hostilities, rebellion, terrorism, riot, strike, lockout, encountering munitions of war, or natural catastrophes such as earthquakes, tsunami, volcanic activity, hurricanes, typhoon. Now, what is interesting is that there's no mention of epidemics in that list. So that's somewhat surprising. As we noted earlier, FIDIC does refer to an epidemic in some provisions. And but however, I think it's very the list itself is not exclusive. They are really examples, if you like, of exceptional events. And provided an exceptional event comes within 1 to 4, then notwithstanding it's not specifically referred to in the list of specific exceptional events, it will still qualify. I think it's safe to say that the COVID-19 virus can be an exceptional event, since it's certainly beyond the party's control. They certainly couldn't have reasonably provided against it before entering the contract, and obviously it's not something which I think you have a good argument to say it's not something which can be avoided or overcome, and obviously it's not substantially attributable to the other party. So I think it's quite clear that the COVID-19 virus situation will qualify as an exceptional event under the contract. So where the party that's affected by an exceptional event, it must give notice within 14 days of when it became aware or should have become aware. So there's an objective test of the exceptional event, and it's then excused performance of the prevented obligations. So it's obviously important to note that it's only those obligations which it's prevented from performing as a result of the exceptional event. It's only those obligations where the performance is excused. So all obligations which it can perform, notwithstanding the exceptional event, it must continue to perform. The affected party also has to give further notices, essentially updates of the effects of the exceptional event every 28 days. In addition to what we've just been discussing, the provisions we've just been discussing under Clause 18, it's provided that if an event occurs outside a party's control, including an exceptional event, which makes it impossible or unlawful for either party to fulfill their contractual obligations, or under the governing law entitles them to be released from further performance, and they can't agree an amendment to the contract that allows performance to continue, then either party may give a notice and then they are discharged from further performance. So obviously in English law, this might be where the event constitutes frustration under common law. And again, or I think specifically in this case, you can see that it might be argued that the restrictions which have been brought in as a result of the COVID-19 might make it impossible or unlawful in certain situations, or at least for certain projects, for the contractor to continue. Obviously, the government has been at pains to make it clear that it has banned construction projects. I mean, obviously in Scotland, some sites have been closed, but in England, for example, the government has been at pains to make it clear it has not actually closed sites, and projects can continue provided they observe social distancing. So I think that it would be quite difficult for contractors to argue that to rely on this provision. So regarding insurances, it's expressly stated under clause 19 that the insurances which are stipulated as being required to be taken out by the contractor, they are the minimum required by the employer, and it's for the contractor to consider what other insurances he needs to take out as he deems prudent. Obviously, again, it's unlikely that contractors would have even remotely would have thought to themselves they need to try to take out some sort of insurance in relation to COVID-19 specifically, etc. Although they're following the effect of the SARS virus back in 2002 to 2004, I do understand that some insurers did amend their policies to actually contemplate that such a virus could occur again, and essentially they amended their policies to limit their exposure. So the contractor is required to insure in the joint names of the employer and the contractor against liabilities for death or injury to any person arising out of the performance of the contract. So this is the third party liability. So this essentially is the insurance that's underpinning the indemnity that the contractor provides to the employer in relation to third parties' claims. And the contractor is also required to insure against liability for claims arising out of the execution of the works in respect of injury, sickness, disease, or death of his own personnel. So this is obviously essentially employers' liability insurance and subcontractors' employers' liability insurance. However, it's important with regard to the clause 19.24, although it refers only to death or injury, and it doesn't refer specifically to disease. In public liability insurance policies, bodily injury also usually also covers disease. And but in relation to, it's important to note that in relation to both employers' liability insurance and public liability insurance, for those policies to respond, legal liability is required. So there has to be it has to be shown that there is liability at law. So the contractor has failed to do something. So he has classically he's in breach of statutory duty or is negligent for those policies to bond. It's also worth noting that as I mentioned, some insurers have amended their policies following SARS back in 2002 and 4, and it is actually possible that employers' liability insurances could exclude the the COVID-19 virus. And that now, obviously, those policies won't name the COVID-19 virus, but they may, for example, they may have a list of diseases which are covered, and by virtue of the fact that the COVID-19 virus is not one of those mentioned, it would be excluded. The employer himself may take out delay in startup insurance or advanced loss of profit insurance, and these insurances which employers sometimes take out in order to protect themselves from delays to their project. The problem is, though, is that for those policies to respond, there must be physical damage. So again, those policies will not help employers in relation to the COVID-19 virus. Okay, so regarding claims, just summarising the various claims which the contractor the parties might obviously be able to make in relation to the impacts of the COVID-19 virus. So if there are some problem with the engineer being able to issue drawings or instructions which the contractor needs for the works, and therefore the engineer fails to issue a drawing which the contractor has requested by notice. If the engineer fails to issue it within a reasonable period of time, then the contractor can claim extension of time and cost plus profit. If the employer fails to obtain the planning zone or building permits, so planning permission and similar permits, again, that could give rise to a claim. And again, you can envisage a situation where, as a result of the virus, there may be, I mean, in most cases, employers do not even start these projects unless they have the planning permission in place. It's just too risky. But if for whatever reason on a particular project they're not in place, and then there are delays because of obviously the problems caused by the virus, then the contractor would be entitled to claim essential time and cost and profit. Again, if the employer isn't able to give the contractor access to and possession of the site, which again you can envisage could happen as a result of the virus, again the contractor would be entitled to claim essential time and cost plus profit. If there are unforeseeable shortages in the availability of personnel or goods or employer supplied materials, if any, which are caused by epidemic or governmental actions. Again, here is an express reference to epidemic. So in such case, the contractor would be entitled to claim extension of time. So if as a result of the COVID-19 virus, he suffers shortages in availability of personnel, goods, or employer supplied material, the contractor would be able to claim essential time, but not cost or profit. If the public authorities or the private utility entities in the country where the project is being constructed, if they delay or disrupt the contractor's work by, I mean, the most obvious thing is perhaps they don't issue permits, etc., when they should do. And if the contractor has diligently followed their procedures and the delay or disruption was not foreseeable or would not be foreseeable by an experienced contractor at the base date, then the contractor can claim extensions of time, but not cost or profit. If the engineer starts a suspension of the work, then again, contractor can claim cost, profit, and extension of time. If there's unreasonable delay by the employer in permitting access to the work, so this is during a defect notification period, so where the contractor needs access in order to remedy defects. If there's any unreasonable delay by the employer in permitting access, and access has to be permitted right up to the date, which is 28 days after the issue of the performance certificate, then the contractor can claim cost and profit. And if there's a change in laws after the base date, we discussed change in laws earlier, then a contractor is entitled to, so this again may be emergency regulations which have been brought in to combat the COVID-19 virus, then again the contractor is entitled to claim extension of time and cost, but not, as discussed earlier, if an exceptional event occurs, the contractor can claim extensions of time. In terms of the employer can claim additional costs if the contractor doesn't manage to obtain all other permits which are required for the execution of work. So the employer is specifically required to obtain the planning and the building permit and the zoning permit, etc. All other permits have to be that are required for the execution of the works have to be obtained by the contractor. If there is some delay in obtaining those or failure to obtain those as a result of the COVID-19 virus, then an employer suffers additional costs, then he could theoretically claim those costs from the contractor. Okay. So just to in terms of to conclude, I think it's very clear that the FIDIC 19 contract, whilst it only refers in perhaps two provisions specifically to epidemics, it's very clear that it does provide contractors with quite extensive protection relief from possible consequences of the COVID-19 virus. And so it's protections such as the change in law provisions, the exceptional events provisions. So I think it's fair to say that the contractors do have quite extensive provision, but it's also clear that what the contractor must do is that he must issue the relevant notices, he must provide the relevant information by way of progress reports, revised programs, etc. And the onus is on him to be on the front foot. Okay, so that concludes my talk, and I'm happy to take any questions.
Okay, Chidi, that's good to hear, because we do indeed have some questions for you. We've had them coming in during the course of your talk, so that's great.
Okay.
I've started to load them onto the chat box for you, but whilst you're just loading that up, first question in was, can there be circumstances under FIDIC 2017 whereby the claimant will be entitled not only to extension of time, but also to compensation due to the coronavirus, the latter being a neutral event? However, what about contractual risk allocation or only force majeure? What are the prerequisites for financial remedy as well as EOT?
Okay, I think I've actually already covered that question, but let me just go back to the relevant slide. So if you look at the slide which I've now shown, unforeseeable, one example might be the contractor may suffer shortages in availability of personnel. So he may have personnel who are in quarantine, who may contract the virus, and so forth, or he may suffer shortages in goods, so in contractors' equipment, because of restrictions, etc., which the government have brought into play. And as you can see on the slide, in that event, he wouldn't be able to recover his costs or his profit. He would simply be entitled to extensions of time. And similarly, the one which follows, again, if he's delayed or disrupted by the private utility entities or public authorities, again, it's time only. But if you then go on to where the engineer has gone on the front foot and he's actually suspended the works, then the contractor would be entitled to recover time, cost, and his profit. And again, if there was a change in law, the emergency regulations and laws which have been brought in, if the contractor is able to frame his claim on the basis that there has been this change in law which has affected me in the execution of the works, etc., he can claim both his time and his cost. Again, an exceptional event which we discussed, COVID-19 virus is likely to fall within the definition of an exceptional event, and it's time only. So I think the lesson is the contractor, it depends on how the contractor frames his claim, which particular provisions he can bring his claim within. It's obviously in the contractor's interest to try to bring his claim within the change in law provisions, and if the engineer has decided to suspend the works, then that obviously would make it easier. But I think that most engineers will probably not do that for that very reason, and they will, again, most engineers are unlikely to instruct variations. Again, for that reason, they don't want to lay themselves, the employer, open to claims from the contractor for cost as well as time. So I think the most obvious avenue for the contractor to seek to recover his costs as well as essential time is the change in law provisions.
Okay, the question just prior to that, sorry, I got these in the wrong order. Do the 2017 FIDIC suite of contracts maintain the principle that failure to provide with procedure as to notice the contractor loses the entitlement altogether, the no ambush theory, but subject to that only prejudices his right to a remedy but does not lose it?
I mean, it's a good point. I've actually covered this point in a previous talk. It's quite I mean, they do maintain the principle, but it's not as simple as that, because essentially, although, I mean, the question is basically asking whether there are still time bars. I mean, the FIDIC 1919 contract, if you didn't comply with the notice provision, so if you didn't provide the initial notice of a claim on time, the claim was time barred. And then if there was some other failure, so if you didn't provide the particulars when you should have done, or they weren't of the sufficient sort of content, then you weren't time barred, but it then was considered, well, what prejudice had been suffered by the employer as a result of the failure to provide the particulars on time, or the inadequacy of them. So that's FIDIC 1919. FIDIC 2017, it's not that they have essentially maintained a similar approach, but it's more complicated than that, because what they now do is even the time bar is not a straightforward time bar. It then depends on, it requires the employer, for example, to actually issue a notice to the contractor stating that, oh, you have time barred, your claim is time barred. So the employer is required to issue a notice within a specified period of time. And if he doesn't do so, then the claim isn't time barred. So it's more complicated than under the FIDIC 1919. It's far more complicated, and I think it's going to give rise to a lot of satellite disputes. So yes, if you like, at a very high level, the principle has been carried over of time bar for notices and prejudice used for other failures with regard to claim procedures, but it's a lot more complicated in FIDIC 2017.
Okay, thank you for that. Another question: in the event that the price inflation schedule was not envisaged in the contract, and at the resumption of the works after the COVID-19, there's obviously inflation there, how will this be dealt with, knowing that this is a risk that cannot be left on the contractor alone?
Well, I mean, again, a good question. If I was I think it comes down to if there has been a suspension, you would obviously try to claim your costs of the suspension. If you're the contractor, you would argue that those costs have arisen as a result of the suspension. if there hasn't been a suspension, so if the contractor has himself stopped work because he has deemed that he has to, as a result of the social distancing and not being able to meet the social distancing requirements, then it's a more difficult question, and I don't think that the contractor could then seek to claim any sort of price inflationary increases because of the hold up of the job. So I think it depends. If it's a suspension which is instructed by the engineer, then I would expect the contractor to argue that by reason of that suspension, he has incurred some price inflation, and therefore those are costs of suspension which come within clause 8. Clause 8.
Okay. What is the position of the performance bond under clause 18 when there is a release in the performance under the law? Is it still subsisting, and is the contractor under any obligation?
Sorry, Julie, can you repeat that? I didn't quite catch some of that.
Okay. What is the position of the performance bond under clause 18 when there is a release in the performance under the law? Is it still subsisting, and is the contractor under any obligation?
Well, the way the performance bond works is that it has to stay in place until termination. So effectively, a release under performance of the law should be treated as if it's a termination for an exceptional event. It should be treated in a, I would expect it should be treated in a similar way. So the performance bond should come to an end, and it should be returned to the contractor, apart from claims which have arisen prior to the date of discharge or termination.
Okay, and then the last question that I can see, what is the remedy if the engineer fails to issue instructions to suspend the works under clause 8.10? Can the contractor stop work by issuing a notice?
No, it's the engineer's. The engineer has the power to instruct a suspension. There's no requirement for the engineer to do so, and the engineer, as I mentioned, the engineer may decide that it would not be in the employer's interest, and it's not something he is required to do. I mean, the engineer has to hold the balance fairly between the parties, so he's not just there to do the employer's bidding. But the engineer could decide that he is not the person who he is not in control of the works, it's the contractor. Therefore, it's for the contractor to decide whether he can comply with the social distancing requirements or whether he cannot, and therefore needs to stop work and seek relief under, for example, the change in laws provisions or the exceptional event provisions. So there's no mandate that the engineer must instruct a suspension.
Okay, that seems to cover all the questions we've been asked. So thank you very much, Chidi, for your time and sharing your expertise with us.
Thank you.
The recording of this will be available at some point this week on the website in the usual place. We have other events coming up. Please check online for all of those. Other than that, we'll say good night to you all. Thank you for attending. Please stay safe. So thank you to all of you, and thank you again to Chidi.
Okay, thank you. Good night.